As far as anyone can tell, 11-year-old Lucretia Murray was the youngest person ever charged with capital murder in Texas. A savage killer, prosecutors say. But enough people, including Amnesty International, have enough doubts about her guilt that they've made Lucretia a poster child for juvenile injustice. Before all this, Lucretia Murray was a more or less typical sixth grader who enjoyed basketball and church. She was a mediocre student who regularly complained about homework. And then one day she went to prison for up to 25 years. The Austin, Texas police say that she brutally beat and killed 2-year-old Jayla Belton, who had been dropped off at a daycare center Lucretia's grandparents ran in their home. Lucretia Murray, who's now 14 years old, was twice convicted of killing Jayla. Although a judge threw out the first conviction, the second jury quickly found her guilty again, and she's spending her 3rd year in custody with the prospect of another 22 years behind bars. You want to be a lawyer, I understand. Why?
So I can help people staying out of places like this.
What did you think of the trial? 2 trials.
I didn't like them.
Why?
'Cause I'm here. They didn't work right.
Did you kill Jayla Belton?
No, I did.
And Barbara Taft, a former legal secretary, believes her.
Nobody did their job in this case. The police didn't do their job in investigating this case. The medical examiner didn't do his job in a proper autopsy. A prosecutor takes an oath to seek the truth, not to prosecute the person in the chair, but to seek the truth. Nobody did that in this case. Nobody.
Barbara Taft was so disillusioned by Lucretia's prosecution that she quit her job at a prestigious law firm in Austin. Now she leads monthly marches to protest Lucretia's conviction, but the prosecutors pay her little heed. Attorneys Rosemary Lemberg and Gary Cobb work for the Travis County District Attorney. 2 of you sitting there right now, you are satisfied she committed the crime and is serving the time?
Yes, sir. But
beyond the shadow of a doubt?
Beyond a reasonable doubt. But what we believe really isn't important. What's important is that 2 juries, 24 individuals, have been convinced of her guilt.
At 6 p.m. on a spring day back in 1996, Lucretia Murray and her grandfather, R.L. Murray, showed up at Brackenridge Hospital with Jayla Belton's lifeless body. Her body showed more than 30 bruises, 4 broken ribs, and a severely damaged liver. She'd been dropped off at the daycare center earlier that morning by her mother's live-in boyfriend. And what led prosecutors to name Lucretia as their prime suspect was the fact she was the last one alone with Jayla.
The key thing is, when did the fatal injury occur? And there's no doubt that that took place just minutes before Lucretia brought her out for her to be taken to the hospital.
And the reason you say that is because a child could not survive more than 15 minutes, according to doctors with a split liver.
According to everyone, no child, no adult could survive for that length of time.
But Lucretia's defenders cite evidence that Jayla was already injured and hurting when she was dropped off that morning by the mother's boyfriend, and that once there, she refused to eat, slept, and that there was blood in her vomit.
She was constantly holding her side.
5 days after Jayla died, 11-year-old Lucretia was charged with capital murder. Had she been an adult, she could have gotten the death penalty.
Lucretia Murray was Travis County's very own, very first child killer, and they could taste it.
After Jayla's death, Lucretia had been taken from her family and detained in a children's home where she was questioned at length by police without an attorney or a family member present.
I believe there were 2 police detectives that did the primary questioning.
Judge John Dietz presided over both of Lucretia's trials. She was taken by police from her home, taken to a facility, stayed there, I believe, for 4 days.
4 or 5 days, yes, sir.
She doesn't have an attorney and no member of the family?
That's correct. And your question obviously is, well, isn't there something in Texas law that says that she must be provided an attorney under those circumstances? And the answer is no, there's not.
You have lots of friends in the legal profession, no doubt. They have children. They turn 11 years old. Can you imagine that any one of them would want that child to be interrogated without a parent there? without an attorney there?
Well, of course not, Mike. I am a judge. I'm not a policymaker. It's really up to the legislature to provide that right to the citizens, to the children of Texas.
Barbara Taft has read the transcript of the police interrogation.
No, she said 39 times. Do you hear me? 39 times in the course of 3 hours. I don't know what happened.
Finally, though, after 4 days away from home, Lucretia weakened. Attorney Keith Hampton, who's now handling his young client's appeal, says that she was pressured, prompted by a police detective into signing a statement admitting that she accidentally dropped baby Jayla after she found her shaking and whimpering, and that she kicked Jayla as she was picking her up as she rushed to bring the baby to her grandfather. Attorney Hampton has also read the transcript of the police interrogation.
He tells her in this speech that we won't have to be bothering your family and your grandpa. The signal is, go along with this, and you know, you can save your family from detectives like me.
They needed a confession. They had no physical evidence. They had no forensic evidence. They had no witnesses. They had nothing. Therefore, they were desperate to get a confession.
Lucretia Murray didn't get a lawyer until after she was charged with murder, and that lawyer assigned to her by the state of Texas had never tried a murder case before a jury. And he was given so little money to work with that he never hired a medical expert. How important is medical testimony in a case like this?
Extremely.
Very important. And it helped pinpoint Lucretia.
Absolutely.
How could her first attorney fail to hire even one medical expert to challenge the state's theory of the case?
I really believe that that was more my fault than his, in that I had limited the amount of resources. I mean, at the time, we did not realize the amount of controversy this was
going to cause,
going to garner.